Hello, everyone. My name is Jamsheed Peeroo, and I'm a barrister and an arbitrator at 36 Stone, which has offices in London and Singapore. I also practice from Peeroo Chambers in Mauritius. I would like to thank the organizers for giving me the opportunity to address the very important topic nowadays of virtual hearings in international arbitration. Virtual hearings have been around for several years in international arbitration, and following the current pandemic, their use has greatly increased, and it can now be said that they are becoming the norm in international arbitration. A number of important practical and legal issues must be considered when organizing or participating in the virtual hearing of international arbitration matters. Let us first look at how virtual hearings are organized. Often, it is for the arbitral tribunal itself, sometimes with the assistance of an arbitral institution, to organize a virtual hearing. The tribunal may also ask the claimant or ask both parties jointly to investigate the possibility of organizing such hearings and to provide quotes from relevant service providers to the tribunal. Nowadays, given the extensive use of virtual hearings, I find that tribunals tend to organize the hearings themselves using mainstream video conferencing tools rather than hiring service providers, which were once called upon to organize what I would call quasi-virtual hearings, where, for instance, only a witness who could not travel to the physical hearing had to be heard. And by mainstream video conferencing tools, I mean Zoom, Microsoft Teams, Blue Jeans, and the like. And of course, breakout rooms can also be organized by the tribunal using these tools, or by simply organizing a separate virtual call between the members of the tribunal for deliberations, and counsel teams can also have their own parallel virtual calls to discuss and prepare, for instance, during breaks. Now, the use of a virtual hearing can raise legal complications where the law of the seat of arbitration does not state that the venue of hearings can be held outside the seat of arbitration, so that all hearings must physically take place within the seat of arbitration. However, this is quite rare, as most leading arbitration seats do afford flexibility as far as the venue is concerned, and the choice of a venue normally ultimately rests with the tribunal after it has consulted the parties. A difficulty arises where parties have, in their arbitration clause, specifically chosen the venue of hearings too. For instance, where the parties have expressly required hearings to be held in New Delhi, will this requirement be satisfied if members of the tribunal are physically located in different countries, or if the counsel of parties are also in different places? And even if it so happens that all members of the tribunal are in New Delhi, although they are in their respective offices, and so are counsel of the parties, will the condition of venue being in New Delhi satisfied if the virtual hearing tool selected has its servers in a different country? Because technically, that is where the electronic image and sound of the individuals participating in the hearing are actually meeting. Because one should not forget that under the New York Convention, a ground for setting aside an award or for refusing to enforce it is that the arbitration was not in accordance with the agreement of the parties. Therefore, this will be an essential consideration for each and every tribunal when faced with an express choice of venue, given that the tribunal generally has a duty to make an enforceable award. And of course, under most leading arbitration rules, the parties also have duties to cooperate with the tribunal, to act efficiently, and so on. But I'm not entirely convinced that such duties can trump an express choice of venue. One can therefore only hope to be able to count on the cooperation of all parties in order for a virtual hearing to be held in such a case. And if the parties do not agree, perhaps it will be more prudent to postpone the hearing until all can safely travel to the chosen venue. Now, with that in mind, let us look at some other aspects of virtual hearings. Virtual hearings will require some adjustments to be made by all professionals involved. For example, the counsel will not really be able to make eye contact with each member of the tribunal. He or she will rather be staring at a screen or at a camera. And counsel will have to be at least as easy to hear, see, and follow as opposing counsel is. This may involve using special lighting and a microphone in the room, and obviously upgrading one's internet connection. And the same will apply to members of the tribunal. Let's not forget the fundamental requirement of a fair hearing. The task is to hold virtual hearings that are appropriate and perhaps sufficiently comparable to a physical hearing, so that one can say that this was indeed a fair hearing. Even if seamless communication is achieved, a respondent could theoretically object as far as the hearing of witnesses is concerned. Indeed, where an arbitration will be determined mostly on documents, the issue of a fair hearing hardly arises. But let's imagine a case where, for instance, fraud is being alleged based on a verbal misrepresentation of a party's office holder at the time of the signature of the contract. The determination of such a case may well turn on whether the tribunal believes that testimony after examination in chief and cross-examination. So one can clearly see how the quality of internet connection, of the quality of the software itself, and of the hardware used can play an important role. In fact, a respondent might object to such important testimony being heard virtually on the basis that the hearing will not be fair. Because judging the truth of testimony is not limited to the words being spoken, but also to the demeanor, expressions, and reactions of the witness. Besides, in such cases, the parties may require that a 360 degrees camera be used in the room in order to make sure that that key witness is not being assisted during cross-examination. I have, in the limited time allocated, tried to discuss a few difficult questions that may arise in virtual hearings, and the answers will obviously depend on each case. And we can expect a few challenges to arbitral awards being brought before the courts, and it remains to be seen what approach to virtual hearings will be adopted by the judiciary in setting aside or enforcement proceedings. On a good note, virtual hearings are more environment friendly because they reduce the need for travel. And virtual hearings are, in fact, also indirectly promoting the use of electronic documents so that arbitration is also becoming paperless. As far as the future is concerned, in my view, virtual hearings have already become mainstream in international arbitration, and one doubts whether they will not continue to form the majority of hearings after this pandemic is over. Sorry. In conclusion, I think one can safely say that legal solutions will swiftly be established by the courts to cater for the few difficulties that may arise with virtual hearings. And until then, whilst there may be no choice but to hold a virtual hearing in most cases, the perhaps most prominent part of the label must still read, use with caution. Thank you very much.